When you live with someone under similar circumstances to a marriage or civil partnership, it is important to understand the implications if you decide to split up. You may find yourself out in the cold in terms of what you can walk away with. Deborah Cahill explains some of the possible pitfalls when it comes to cohabitation and property, and how you can protect yourself with a cohabitation agreement. So Debbie, if you cohabit, surely you have the legal rights if you decide to separate?
Not necessarily. It all depends on the circumstances of each individual couple and how they own their house, what their circumstances are financially, whether they have children. Many people believe that there is common law marriage, which gives people the same rights as married couples, but that is not the case. Basically, with a cohabiting couple, unless they have set out some form of agreement, the person who doesn't own the house, who's moved into somebody else's, may have no rights whatsoever. That's why it's important to set out what your arrangements are early in the relationship.
So what are some of the pitfalls if you don't have a cohabitation agreement?
Basically, the parties may have made no agreement in relation to who has what interest in the property, and that may lead to disagreements when they come to separate and difficulties in trying to ascertain who has what interest in the property, who has the rights to live in the property, and what arrangements are going to be made regarding the children. Often the problems arise in relation to possessions and finances, but particularly in relation to child arrangements and where they're going to live if you haven't made a cohabitation contract early on in the relationship.
Okay, so if a couple cohabit, surely they both have a right to the home they live in together?
No, that's not the case, and people do think that a cohabiting couple, the person who isn't the owner of the property, may gain rights over the property. That is not necessarily the case. It's therefore important when people do move in together that they consider how they're going to contribute towards finances, etc., and whether they intend for the other party to get some form of interest in that property. If the property is owned by one of the parties, only they have the right to live there.
Is it always the case then that the person that owns the property is the only person with the right to live there?
That's not necessarily the case, because if there are children or if the person who's moved into the property has made contributions to that property, they may gain some interest in that property. It's therefore important to have some form of agreement between the parties as to what interest they both have and whether they have the right to occupy the property.
So what about then when children are involved?
Quite often in the situations where children are involved, the issue of the occupation of the property has to take into account the children's needs, and that may be the case that the non-owning party, who may have the care of the children, seeks the right to remain living in the property with the children while the children are minors. That's a very complicated, in fact, situation, and it would be important to set those arrangements out early to prevent disputes in the future.
So Debbie, surely it's simpler if a property is jointly owned?
Not necessarily. Where a property is jointly owned by the parties, one person wants to sell and the other wants to stay in the property, there can be a dispute and there can even be court proceedings in relation to that matter. It's therefore important to set out early on what the parties' interests are in the property and what the intentions are for that. Otherwise, you may find that one person has paid much more money and doesn't get the return they expect of that, or that there is some dispute about who will live in the property in the future, particularly when there are children involved.
So how will a cohabitation agreement help?
That will set out in very clear details what the parties intended at the time of the agreement, that those issues that may be important in the future have been looked into. It can set out what interests the parties have in the property and what the intentions are for the property, particularly in the future. It will give the parties peace of mind as the settlement has been put in place to deal with any issues arising from separation.
Is it legally binding?
It is legally binding. It is a contract like any other contract where the parties intend to have legal relations between them and they intend to be bound by the agreements that they have made. So it can be enforceable.
So how would someone start getting a cohabitation agreement in place, Debbie?
It's really important in these circumstances to make sure you understand what you want to put in such a cohabitation agreement, and I would suggest it would be important in those circumstances to take full legal advice on those matters from somebody who understands the law in relation to cohabitation matters.
Well, Debbie, thank you very much indeed for your time. Whilst a cohabitation agreement isn't the most romantic notion, speaking with a specialist in cohabitation law and getting an agreement in place can help you both have a peace of mind for the future.